but I understand that his role was initially limited to that of a lay witness. As far as I can recall, the Post Office did not seek to rely on him as an expert witness, or at least initially. Subsequently, due to his expertise and qualifications, the court considered him an expert. Is that correct? That's what you're saying?
Yeah. Isn't that
right?
what I've been saying all along to you any case? But that's what I say.
It follows, doesn't it, that there came a stage when you did consider him to be an expert?
Not by... It's difficult. It's very easy to play with words, but in the practice...
Is that what you think I'm doing? I'm just reading out parts of your witness statement.
Let me think then. Let me think quietly to myself. I was thinking loud. Maybe it's not the place to think loud.
You did consider him to be an expert?
Only as an expert in the horizon.
After that initial period had passed, did you treat him as an expert witness?
Okay. Can I share something with you?
Well, one moment he's a witness of fact, and then the court is treating him as an expert.
So we're going to jump back into Jarnail Singh's testimony to the Post Office inquiry about Gareth Jenkins, and specifically about Jarnail Singh's comments in his witness statement about him. And it's fair to say that Jason Beer, Casey, absolutely tears apart his witness statement in front of him. And he goes backwards and forwards on things so much it's hard to keep track sometimes. But we'll give it our best shot. Let's jump into the inquiry.
Can we look at your witness statement, please, at page 24? Thank you. And paragraph 69, please. We scroll down, thank you. You say, in the Misra case, the defence expert raised questions. I contacted the investigation and security team to ask whether they could answer these questions. I was told the request needed to be made in writing and it could take weeks for a response. I was worried that the normal systems and procedures for obtaining information from Fujitsu would be too slow. So I also contacted David Jones, head of legal at Fujitsu, to escalate the request, and so it would be dealt with as quickly as possible to comply with the court order. Subsequently, Gareth Jenkins was put forward to deal with the defence requests as someone who was in a position to deal with the issues raised by the defence expert. But I understand that his role was initially limited to that of a lay witness who knew the Horizon system well. As far as I can recall, the Post Office did not seek to rely on him as an expert witness, or at least initially. Subsequently, due to his expertise and qualifications, the court considered him an expert.
When is an expert not an expert? I guess when they're a lay witness who knows a lot about what they're talking about. Really?
You see that?
Yes.
So you're saying that you and others within the Post Office did not seek to rely on him as an expert witness, at least initially, but the court did.
Well, I think isn't that what...
Is that correct? That's what you're saying?
Yeah. Isn't that
right,
what I've been saying all along to you any case? I mean, I don't think that is any different to what I've been just telling you.
And then if we can turn, please, to page 67, paragraph 198, you say, initially, I did not consider Mr. Jenkins to be acting as an expert, but to be brought in as a lay witness with technical knowledge who could respond to matters raised by the defence expert. And then at the end, you say, however, this was an unusual case in that he was not regarded by the prosecution as an expert witness, but from recollection went on to be treated as an expert by the court. In both of those paragraphs, you say that initially you did not treat him as an expert witness. Agreed?
Yes.
And in both of those paragraphs, you say that he, Mr. Jenkins, was treated by the court as an expert. Agreed?
Well, that's what I say.
Yes.
Yes.
Well, that's what I say. Well, hopefully, as you've sworn it to be the truth, that's also the case.
And so, if you initially did not consider him to be acting as an expert, it follows, doesn't it, that there came a stage when you did consider him to be an expert. Agreed?
Not by... It's difficult because I think it's very easy to play with words, but in the practice...
Is that what you think I'm doing?
Well, no.
I'm just reading out parts of your witness statement.
Let me think then. Let me think quietly to myself. I was thinking loud. Maybe it's not the place to think loud. Let me put it differently to you then.
Just so you can refocus on the question.
Yes.
In 2 paragraphs in your witness statement,
yes,
you said, initially, I did not consider him to be acting as an expert, ...
Yeah.
And my question is, does it follow that later, i.e. after the initial bit had finished, you did consider him to be an expert?
only as an expert in the Horizon system, because we did not have anybody else to who had that specialist experience into the operation of it, the workings of it, and also even to analyze the transaction logs. And I think overall, in the scheme of things, in the case itself, he, and in turn, because of his expertise and knowledge, he was able to bring the defense expert to a level where he could actually understand the system.
Mr. Singh, in these two paragraphs, your
So he was an expert because none of those things actually changed. Nothing changed, but he's like, well, yeah, because of his expertise, I eventually considered him an expert. So he's an expert from the beginning then. As you said, he had expertise in the sophisticated and specialist software that was Horizon. He was the only one who knew the answers to questions, and he could answer the defence expert.
dealing with Mr. Jenkins' status.
Yes.
As to whether he was a lay witness or an expert witness. And in both paragraphs, you say initially you did not consider him to be acting as an expert witness.
Well, I think throughout.
But then, and I'm asking you, after that initial period had passed, did you treat him as an expert witness?
Okay. Can I share something with you? There would, the way this should have come about, or the way I visualized it, was that there would come a stage where we would get an external expert, whereby Mr. Jenkins would be able to assist our expert, our independent expert. I think that's probably true meaning, where we should have done, but at the same time, I think I was relying very much on the expertise and the knowledge and experience of our counsel, and that didn't come together.
Maybe they were just a layperson with a bit of legal knowledge.
But initially, I think it would have been easy. I think maybe the way it should have been done would have been. Maybe we would have got another professor in. I don't know, but certainly here he did, in the true meaning of the word, he didn't come in as an expert. Maybe here it was very difficult to put it into words what I was trying to say, but he was treated as a witness of fact all the way through, up to including the trial, but.
Well, I thought the court said he was an expert according to his statement, so it can't have been included in the trial.
Maybe it should have been done differently. He should have been, and we should have got another professor in from the outset as an independent expert. But then, who would have instructed him? Who would understand the system? It was that sort of real world problem.
Can we go back to page 24, please? Paragraph 69 at the bottom, last sentence. Subsequently, due to his expertise and qualifications, the court considered him an expert. Did the Post Office argue against the court's treatment of Mr. Jenkins as an expert?
Not to my knowledge. I wasn't in court. Certainly we were represented by a very experienced, knowledgeable counsel. And certainly he was instructed by the investigation officers was there, and I think one of our legal executives was there. I didn't get anything to anything like that. We said no, he's an expert. He's only an expert of fact.
So did the
I mean, presumably the Post Office didn't argue against the fact he was an expert because A, that was what he was considered as, and B, it would have been good for their case for him to be considered an expert.
Post Office acquiesce in the court's treatment of him as an expert?
I don't know. I mean, I can't answer that. I mean,
when did the court subsequently consider him an expert?
Well, that was. Well, maybe it was wrong. I mean, doing this statement after a long period, after the conclusion or the case has been concluded, it was a difficult one. I would have.
From when? What moment did the court treat him as an expert?
I don't know. I can't answer that.
Was Mr. Jenkins made aware of the change in status that he had enjoyed?
How do you mean?
Well, one moment he's a witness of fact in the person who's calling him as a witness, and then the court is treating him as an expert.
Well,
Was he informed of his change of status?
he basically was treated as if somebody who knew the system well, because that's more or less what the court issue in the case was. And I think as you would be aware, I think the judge actually said to the defense expert and Mr. Jenkins to have as much meeting, as much time as possible, with view to narrowing the issues to a point where there was actually a joint report, which both these gentlemen agreed to.
And is that normal in your experience for court to order two parties to meet, one of whom is an expert and the other who is a lay witness of fact, and to produce a statement of agreement and disagreement or a joint report?
Well, I've just said, I think we've been, for the last few minutes, I told you this is the first experience in the post office cases I've ever had. And I think I was very much relying on, our barrister basically saying, no, we can't use him. I mean, if he said to me right from the outset, Jarnail, we can't use him, then I would have stopped at that moment and see if we can try to find an expert outside, who was basically a professional expert, who gave evidence in court. But this was the only person that we were who was put forward, who knew the system very well, because this was a very, very specialist system. Only person who could actually not only assist the court, but actually went on to assist the defence expert.
I mean, I think what he's trying to get at here, and really the honest answer would be, well, if there was an expert and a non-expert put together, then sure, the court would take the expert's view over the non-expert's view every time. So I think what Jason Bay is trying to drive at here is, well, are we rewriting history now? Because, there's been things said afterwards about his testimony. Are we now deciding that actually it's best if we didn't consider him an expert, even though he might have done at the time?